Everybody ready?
You're
We'll
on.
get started. Are you recording?
We are
Okay.
streaming this time.
All right. We're getting feedback.
I'll play with it while you talk.
Okay. Okay, again, I want to apologize. Had a family medical emergency, so I apologize for being late. But anyway, I'd like to call to order the July 12th, 2022 meeting of the Delaware County Land Reutilization Corporation. Special meeting to consider the Ohio Department of Development Building Demolition and Site Revitalization Program Grant Agreement. So, with that, I will open it up. We did, just kind of by way of background, we got the agreement from the Ohio Department of Development, and it doesn't answer all the questions by any means associated with the demolition grants. And so anyway, but the grant has to be, the agreement has to be signed and submitted by July 20th, 10 business days. I think we got it last Thursday, I think, Sarah, I think it was.
I'm gonna say yes, the 7th.
Wednesday evening, Thursday. And sent it out so everybody have a chance to take a look at it. I know Scott, you said yesterday you would have a chance to review it.
I did,
Okay,
yes.
great. So anyway, I think what we have to do today is get approval to sign the agreement. And assuming that happens, then we go to the next stage, which is to get information on how these grants are going to be administered. First of all, as I understand it, we don't even have official approval of the individual grants. But we're asked to sign the agreement and figure out how to go forward. So anyway, with that, I will open it up to comments. Obviously, we'll have Scott Gordon, our attorney, review it or give us his comments and reviews. But I wanted to acknowledge that Dave Eflin and Diane Gunther did a really nice review of the agreement and sent everyone an email kind of summarizing their findings. It was very helpful, very insightful. This is it's a little confusing. The whole process is a little confusing. And there's a lot of uncertainty still at this point. And the timeline, obviously, to get the agreement in is very tight. And then even after that, assuming we get the approval to go ahead with the demolition grants that we applied for, then we still have to have those completed by next May. So anyway, Dave, I don't know if you want to kind of walk through maybe yours and Diane's review first, and then we'll ask Scott for his review comments.
Yeah, thanks, Jeff. I think it's definitely evolving
Yes.
direction from DOD, even back from when they called for grant submissions. It's been evolving, so that's just part of this program. And we either kind of decide we're just not going to move forward, and I think we all have decided that we got good applications in front of us, but or we decide we're going to move forward and then decide how we're going to figure it out from there together with ODOD. I think I agree with you, Jeff. I think at the moment, and relying on Diane's expertise, really looking at this grant agreement, it's pretty boilerplate DOD language. I think we should try to move forward with this, but there are some. We have subrecipients in our grantees. We have administration, which we can't just. I think we could probably push down to the grantees to a certain extent, but we're going to have to monitor and help and guide. And I think Treasurer Ranke's going to have to set up some accounts and other things that the state wants. Everything's electronic submission and reimbursement and all that kind of stuff. So what we're thinking now, Diane and I, and assuming we move forward today, or whenever on the grant agreement, we've done some more thinking since Friday.
Yeah. Didn't have much time to work.
Specifically, Diane has spent a lot of time in that and kind of produce what she thinks, and I'll review it, go over it with her and add my comments, but what we think is kind of the step-by-step playbook moving forward, and we can talk about it and decide what we want to do from there, but we're thinking that maybe an addendum, and I'm interested in Scott's review, but maybe an addendum to the subrecipient agreements that we already have in place with our grantees as to some certain items, holding us harmless as a land bank, making sure they have money to do the projects in the event ODOD doesn't, for some unforeseen reason, approve the project. Other things that we're still putting that together. I'm not ready to give to you, or else I would give to you, in terms at least of our thoughts. But that seems like a logical next step. We'd want Scott to review it, and we'd obviously want to get input,
Yeah.
from our grantees.
Yeah, that's one of my biggest concerns with the ODOD email and agreement is they still haven't approved our projects.
No, and
Individually.
the word we're getting back kind of informally, I guess, is that this is just informal word we're getting back, okay, so I have no documentation to rely upon this, but that once land banks do the grant agreement, then DOD would review the full slate for that land bank.
That's how they're handling all the counties? Or?
And I think that probably, if I put myself in their shoes, instead of just picking off a project here and a project there, I'm doing Toledo, or I'm doing Delaware, or I'm doing, whatever. There'll still be the 10-day cure period, and
Right, they could have issues with the various applications, back and forth,
they could.
curing.
They,
So, yeah.
they could. I would assume because there's a state law behind this and there's interest in moving these projects forward. And in my experience with DOD, typically they will try to work with you to cure items. They don't, it's not to their advantage to try to claw back things and have projects go awry, but it can happen. So I think we need to be careful about that, and then I think we need to also think about how we as a land bank can administer this, produce the quarterly reports. Obviously, subrecipients are gonna have to produce a lot of that information. And I'm gonna have to talk to Diane and obviously my city manager as to how much time we can continue to spend in that, but I think we're invested, just like Dave and Jeff. I mean, we've gotten it this far together.
Yep.
David, would there be an opportunity for the corporation to reach some kind of an intergovernmental agreement where we would agree to reimburse the city for services to help us administer this grant, since we don't have staff?
Yes, I mean, there could be. I think our grant did not, we felt like we needed all those dollars in the projects, and when we looked at each project even, local entities maybe putting in some dollars. Maybe
I don't know that we could even charge that to the grant. I think we'd
No, I don't
have to
think
we'd
we-
have to pay for that out of our general
That's what I'm
budget.
saying, yeah. So we can certainly talk about that if the board is open to it. Typically with DOD grants, there is an administration line like CDBG. There's a typical, it's usually 10%.
Right, yeah. familiar with those.
That we do take when we administer a city grant, for example. There's a lot of work in these, especially when it's not a well-worn path,
Right.
but
It's a new trail.
And there's going to be check boxes, I'm gonna call them check boxes for lack of a better word, that at key points in each of the sub-grants, we're gonna have to review where they are and that, conditions were met locally, because they're gonna be local
I agree, Dave.
ordinances
And
or
when we do our
local
sub-
practices that are gonna govern this as well.
Yeah,
And who's gonna do that? I
There's-
mean,
there's
we
quarterly
don't
grant-
have staff.
quarterly grant reports required by DOD, and when we've done like the NSP program together with the county years ago and other things, and we were the lead entity, if DOD had a deadline for a quarterly grant, we would back up to get information and have review with those entities, so that we could make sure that our report to DOD was as accurate and well done as we could. So I would anticipate that same. That's just the kind of process and the kind of administration that it takes, but I also have to think about with Diane and Tom, just the time. Luckily, we don't have a huge number of grantees, and if several of those are public entities, like the all sponsored by public entities, but
Yeah.
the ones that are more private are probably the ones that would just worry me at this level a little more, because they may not have been through something like this. But in my experience with Diane and our facade program and other grants we run, if you follow her direction, she will keep you on track and in compliance, which is ultimately what we're after, so we can expend these funds for the intended purposes and do some good around the county. That's my thoughts on that.
Okay, and again, thank you and Diane for review and insights. And again, this is a very fluid situation because we still don't know what items, what the process is gonna be, if there are gonna be any issues with the approving these individual grants, and so on. So, and like Dave said, I mean, we don't have staff, so we're gonna have to, retain some sort of administrative expertise to do this.
And the biggest unknown for me right now, and I haven't had a chance to consult with Diane or our grantees about this, is the State Historic Preservation Review, which wasn't initially produced from the state, but we all anticipated that as pretty normal for DOD grants. But I know the city's project has already gone through our local and would fulfill that obligation then. But that was just not an element that I looked at in detail, because we didn't know we had to, for the other grantees. So that's one of those elements that we'll have to work with. Or grantees will have to work through.
Do we have two or three, or how many we have out there?
We got 2
Jurisdictions?
properties in Sunbury. We
How many
got,
jurisdictions? I think there's 5 jurisdictions.
we got 2 properties in
Delaware,
Sunbury, one
2
in Sayota, right? And one in Powell,
One pile.
one in
4.
Delaware.
5?
5 with like 6 properties, I guess. Because Sunbury has 2 properties.
Yes, 7, because you guys have 2 properties.
We have 2 addresses.
Oh, okay.
Yeah, I guess
Is it one application technically?
it's all our property.
Okay.
They have 2 separate properties, I think, in Sunbury.
We care to hear from Scott?
Yeah, Scott?
Yeah.
Yeah, just to clarify, this Sunny V was not one of the applications
Right.
along with the
It was
city?
not.
It was not, all right.
Sunny V, I believe, a
Well, it-
countywide brownfield
Yeah.
grant was made.
Yeah, that
for
was-
which we
Brownfield,
had-
not
I don't think
demolition.
we've heard.
That wasn't even sold until after the deadline for the
For
demolition.
the demolition one, but it was a separate application under the brownfield.
Brownfield,
program,
right.
All right. Dave, I appreciate your thoughts. I echo many of your comments that unsurprisingly, this is written to protect the funds that we're talking about, the 500,000, as well as to give the Department of Development some very broad authority to terminate if they're not seeing compliance by the lead entities. And then I was disappointed that it doesn't even really mention the subrecipients, which I think are contemplated by this program, but it doesn't really talk about responsibility of that, because obviously they're contracting with us. As Dave mentioned, with what was new to me, and I must confess, I'm not well versed in what will be expected with respect to the demolition requirements in Section 7 when it talks about dealing with the Ohio State's Historic Preservation Office. I had already thought about the properties on Spring Street and how they would be subject to the Downtown Historic Commission's review, and so it sounds like from this one paragraph that would satisfy that section with respect to that property. The other properties, without going through this applications, I kind of went under the assumption that all of those are at least 50 years old. If the property's under 50 years old, then jumping through the historic reviews or getting a waiver or release that it's okay to demo those projects, then it doesn't apply. But
I would think they're all gonna be at least 50.
I assumed that all the other 4 projects were over 50, but if they're not, then it eliminates that barrier.
Right.
Certainly, I would like clarification, as it sounds like Dave would, and probably Diane would, about how much resistance or how difficult is it gonna be to jump through the Historic Preservation Office and achieve that box, as Mr. Stage said. But I don't, given how long it's taken to get some feedback from DOD, I'm not that optimistic that this board has that time to really dig into that. And as uncomfortable as it sounds like it makes me and perhaps some of the board members, it's almost the cart before the horse. You'd like to know what's being approved and exactly what's expected of it before you enter into a contract, but that's not how the Department of Development has approached it. I suppose one saving grace, just big picture wise, was this land bank could always enter into this agreement, and then as it finds out more information, or if program or projects are not approved, the land bank doesn't have the money now. It doesn't have to pursue the particular project. It can say, this person's not, the sub-recipient's not cooperating, or this isn't feasible by May 1 of 2023, and then we choose to refund that money back to the Department of Development. So by entering into this agreement, that doesn't get us that far down where we're in a corner and you can't get out of it. Certainly there's an audit requirement that, assuming that we would get the entire 500 or expend the 500,000, that we would have to get an independent public accountant to conduct an audit. Let's see what. The Department of Development maintains a fairly broad authority to terminate this agreement and cease dispersing funds in a number of manners. My presumption is that the Department of Development, like Dave said, does not want to claw back these funds, does not want to keep restrictions on them. They want them used for the project. So I would trust that our subrecipients, as well as this land bank, are going to cooperate with them, and then they will cooperate with us to try to avoid such terminations. I mean, they certainly have to put us on notice about what our delinquencies or failures are, and then we would have the opportunity to fix those. With the insurance requirement, we will, before receiving funds and certainly dispersing funds, we would need to do our due diligence to make sure that our current insurance is adequate and will satisfy the Department of Development. There is a note that says that we have to produce, if they requested a certification of fidelity bonding and collateral security of deposits. Sitting here today, I am unaware if our current policy can issue one of those types of certifications, and then that would be sufficient, or if that would require us to get some additional policy just for the administration of these funds, these 500,000. But that would be on our, as Mr. Stage says, one of the boxes that we must check. And it sounds like everyone is well aware that it probably, for a subsequent meeting, the necessity of discussing, okay, how do we accomplish all this, and can we do it as a board, and how can we get assistance to do that, to make sure that we adhere to this. It goes without saying that additional assistance likely would be necessary just to make sure that we comply with the goal of the minority hiring goal, which is on page 4, as well as ensuring any other contractors that are working on this are using the prevailing wage schedule, and then submitting the proper documentation that then we could submit monthly requests for reimbursement, or no more often than that. And so that's going to take some administration, certainly. I would note that the remedies that it's specifically noted on page 5, that the demand of repayment of grant funds shall be limited to the grant funds that are awarded. And so that's a cap essentially on if everything goes haywire and something, some sub-recipient is not cooperative, and the Department of Development tries to claw back some of these funds, it's gonna be limited to, in total, the 500,000, but more specifically, any funds that the Department of Development would determine were inappropriately dispersed. I went back and reviewed to try to get some clarity as to, okay, what should we expect given this boilerplate language? Some of the questions and answers that went back and forth with representatives of the Department of Development asking about the timeline, because I think it's very tight, as maybe some of the board members might think. The responses the Department of Development gave several months back was that as that deadline of May 1, 2023 approaches, they repeatedly gave assurance that we will evaluate to see if we can grant extensions. That's going on a lot of faith, and unfortunately that seems like the MO of this grant program, especially in the order in which it's being administered, that they're certainly asking a lot of participating entities to say, yes, we want to disperse these funds, we just don't have it all figured out yet. But they've indicated, at least in several of the question and answer responses that were published and distributed, that they intend and acknowledge that a reevaluation of that deadline is likely to be necessary.
So trust us, basically.
Yeah,
Basically, yes.
there's a lot of trust going on here.
Additionally, with costs, as far as reimbursement goes, I wanted to verify, I mean, it keeps using the words reimbursement, but it also, these question and answers did indicate that there are provisions that the funds, contractor doesn't have to do the work, then be paid from a private entity or from the land bank's funds, and then, and only then can you seek reimbursement. It did indicate that anticipated funds could be included within the reimbursement requests. So I didn't think that this agreement necessarily makes that clear, but the other information that's been distributed seems to indicate that, hey, if you know the contractor is going to cost $15,000 or $20,000, he's doing it right here today, we ought to be able to include that even if the cash hasn't been, even if that contractor hasn't already been paid. Because
Hey, Scott,
Yeah.
can I ask you a question on
Yeah.
that? I think we viewed this from the beginning as it would be a reimbursement process.
Yeah,
I don't think DOD has produced yet that reimbursement process.
they have not. No.
So, but reimbursement nevertheless, so I believe when we were working with grantees, and correct me if I'm wrong, I think in our subrecipient agreements, it does indicate that it would be a reimbursement grant. It wouldn't be advancing funds. Now, it appears as if we might have, as you indicate, the right to advance funds. I don't, there's this look back to the beginning of the year, so hopefully none of our grantees have advanced projects and funds yet, but that's one area. But then moving forward, I mean, to me, this is reimbursement. I'm not sure we'd want to advance the funds. That's one of those check marks that we can use as the grantee with DOD.
Yes.
And then our subrecipients to say, okay, get us your documentation. We think you need to cure A, B, and C before we request a reimbursement, because I think most of the terminations and issues are relative to a reimbursement.
Yes. Yeah.
So things to figure out, but I think we viewed it as a reimbursement. And I think our grantees are in a position, or they should be in a position to advance their
To do
project.
that, yeah.
Or request reimbursement. Now, hopefully that happens monthly. I could just tell you in the process of normal construction, this case deconstruction of projects, it's lots of stuff's gonna come up. We're gonna have to handle it. That's part of the administration, working with the grantees.
Right. Well, ultimately, that would be the board's pleasure as to how those funds would be distributed, or when reimbursement, however you define it, would be submitted to the department. But it says that just those requests could be no more frequently than monthly. So,
If you look at Exhibit 2, Item 1, there is provision for advances.
Yes, that's all I was saying. I was simply identifying.
Yeah, that,
But if the board decides that it's not the preferred
that worries
method,
me a
then don't
little
do it.
bit just in this because of all the unknowns. If it was clear, that may worry me less just as a land bank member. I'm not worried for the city of Delaware's project per se, but I think that was clear in our subrecipient agreements early on that it was to be a reimbursement grant.
Yeah.
So I would think if we approve this, move forward, like you say, Scott, I think we can tell our subrecipients, you're not to move forward yet till we figure out insurance and
Right.
administration and that sort of thing.
Yeah.
Well, I think for our purposes, we could request an advance. That doesn't mean we pass the advance through. We just have it available, so as the reimbursement requests are received from the contractors, they're not waiting 45 days to get paid.
You talking advance from the state?
Yes, advance from the state to us. Then we have the cash on hand, we would have the funds on hand. If we approved reimbursement request for a project, we'd be able to pay fairly quickly.
It's interesting. I hadn't thought about it that way. The way I'm seeing the state wanting to set this up all electronically, my sense is that they're looking to speed up that process.
Yeah, but it's still gonna take several weeks.
But, yeah.
Yeah, I think that's something we should look at down the road, as we get into this.
Yeah,
Dave,
it's
did
part of
you-
the administration.
Scott, did you have anything else that?
I think Dave's comments also is an important one that I would recommend that we, if this board moves forward with this agreement, that we also then supplement and our subrecipient agreement as we're learning more, because we want to protect ourselves, also make the subrecipients, put them on notice as much as we can about the board's intention about how it plans on administering this program. So if it's the board's plan to, hey, we're gonna work with you to seek reimbursement for the cost of whatever your project is, you need to be prepared to expend all those funds as that's completed. I mean, this is all after and assuming that the project's approved. That's the caveat that covers all of this, my recommendation was that no one ought to move forward until their project's approved, because if they do, then they're running the risk of the Department of Development considering that cost and work done prior to it being approved. So I don't think
Well,
anybody.
we don't want to be at risk,
Right.
Oh, yeah.
and it really needs to fall on that party if there's a question, not us.
Oh, yeah, it wouldn't be our funds, but if they intend to seek and want to rely upon getting some reimbursement of those funds, they should wait. I think they should wait until the project's approved.
Now, there hasn't been any indication, I haven't seen anything in the emails exactly what the timeline is for getting the actual individual projects approved. I don't think you've seen anything.
Yeah, that was my reference before. We've had some very informal contact. It seems to indicate there's been formal contact that they have received the grant and the project.
Acknowledge that.
The informal one is, I don't know what they reviewed or how they reviewed, or if they reviewed any of the individual projects. I don't think anybody really knows that, but the informal contact has been, we'll wait till the land banks contract with DOD, and then we're gonna take, Delaware's projects.
Okay,
We're gonna take
that's what I
Franklin
thought.
County's
I didn't
projects.
think we'd heard anything.
So I haven't, Diane hasn't. I think they've been trying to figure out the process we're reviewing right now, is what I
Yeah.
suspect.
Yeah. Aside from that, I don't have any other specific.
So Scott, in the subrecipient agreement amendment or changes, what specifically do you think we should change?
Well, I think we could increase and beef up the provisions with respect to them. We already have provisions in the subrecipient agreements stating that they shall hold us harmless. I think we could expand upon the anticipated procedure that they need to be prepared to complete the work, provide all the written documentation, which that is also already in our subrecipient agreements, and and then they will have to plan for reimbursement after that. And that if their project or they don't comply, then they run the risk of not being reimbursed for the funds.
It's on them, not us.
Yeah, right. Now, I would say more or less that's in the subrecipient agreement that they've already signed. We do that in way of, we referenced all of the regulations that were released at the time that we had to submit the applications, and so that we made sure that they acknowledged that they had reviewed all those, they'd received copies of all those, and all of that indicated, you know, in an even broader sense, that monthly, quarterly reports as well as invoicing and other documentation would be expected in order to, or as a part of the reimbursement request. So I think clarifying that and making sure they understand that is likely gonna be the case.
Well, I think typically you would, whatever this final version of this looks like, that gets incorporated by reference into the agreement with the subrecipient.
Right. So they also would
Correct.
have,
Correct.
you know, to review this.
Yeah.
Yeah.
You know, there's a couple of things here that if you look at the program guidelines for this program, as this document sits before us today, they have imposed or proposing imposing requirements on us that aren't in those guidelines, and in fact, those guidelines waive them in some instances. For example, the Historical Society review, the guidelines waive that.
You mean, which guidelines, the previous,
The program guidelines
that we
that are in
received,
effect. There are program guidelines in effect for this.
that we
program
received
right
months
now.
ago? The guidelines that we received months ago is what you're talking about?
They're available. I just look at them online. I don't download them. You know, but the historical review is waived in those guidelines. It's not required.
That's something we should question?
My question is, you know, I think we should, the Land Bank Association is meeting with Department of Development, I believe this morning, to discuss this document. And they're gonna ask for waivers of some of the requirements that are in this document, since they're more stringent than what is in the program guide. Frankly, I hope they're successful. You know, we'll see whether they are or not. But, you know, I think we need to support that effort. I think we need to recognize that that's a possibility when we vote to approve this or not approve it, that, you know, we want to reserve the right to come back and reconsider this. The other thing, one other item that while it's immaterial can be a real problem to comply with is accounting for and applying any program income that accrues to the Land Reutilization Corporation. And I haven't talked to Don yet. I don't know what the requirements are of the Treasurer's Office as far as opening a non-interest bearing account. My assumption is that it can be done because his predecessor did it. And for the few dollars in interest that we would earn while these funds were sitting there waiting to be disbursed for reimbursement requests, they're not worth it. So I think if we can get by with, you know, establish the process where we don't throw off program income that we then have to track and account for and document, we're gonna be better served, and it's gonna cost us less money. Just little things like that.
Well, it's interesting, thanks for sharing on the state land bank. I think sitting here on this board, I think that's an appropriate board to raise those questions
Yeah,
with the
yeah.
state. This looks like,
You know,
the state was clear, though it wasn't in the guidelines, I agree. They were clear, we anticipated that there would probably be some SHPO requirement included. Maybe not even exactly as it's written, because typically a local review that's a little different, depending on the project and your agreement with SHPO as a local entity. But I think that'll be interesting to see what comes of those
Yeah.
discussions. And then, I think if the changes anything, it seems to me that DOD would then push any of those changes down to
New agreement.
probably an amendment to what presumably at that point would be an agreement with land banks all over the state.
Well, as I understand it, David, we all seem to recognize that these SHPO requirements can be an issue, or an issue at this point. The requirements that they've included in Exhibit 4 were for another program
We're for what?
that has since been terminated.
We're for what? What'd you say?
The SHPO requirements that are Exhibit 4 in
Right.
this document were for a program that has since been terminated.
Oh, so you mean just copied?
So you think someone just got lazy and just started throwing stuff in?
Well,
It's pretty typical.
it is
You don't
pretty
reinvent the
typical,
wheel.
and very often people will just throw things at the wall and everything that sticks gets in, instead of thinking it through. So, I think there's, again, other than those SHPO requirements, one of my biggest concerns is how, we're going to have to be able to manage this. We need to be able to fund that process. And I don't think we can count on it being grant funds. I think it's gonna have to be out of our general budget.
Well, the only comment I have on that is at what point all these costs make the program
E-
worthless?
Exactly,
And to
exactly.
me, there's so much bureaucracy here. I'm not saying I'm opposed to it. I'll go with the flow on this, but if I was spending my dollars, I'd say to heck with it. Because I think there's too many roadblocks and too many issues, but that's just me.
Well, I think it was Jeff made the point that, we can adopt this today with the understanding that we can terminate it. Because we do have termination protection.
Before we get into projects, I was thinking, once we're in projects with grantees, we gotta
Yeah, we're
probably need to complete it unless there's some issue. I would say typically, Gary, I might push back a little bit on your statement that, so if it's $500,000 worth of projects we have sitting in front of us, typically if it's 10% admin dollars, $50,000, we have that in our accounts today, if we were to run up that high.
But if we start adding expenses that become fixed and they're year after year, then the cost is more than that. It's gotta be specific to this project so we know what our costs are.
Oh,
And that's my concern. Well, we're gonna embed costs into the process that will extend beyond this.
no, I think it should be specific to this, and we know we
Yeah.
have an end deadline as of now.
Yeah,
It may get extended for projects or whatever. The state has been less inclined to extend dates, although I agree with you, a lot of the early guidance has been,
So
well, if we get there, we might extend it or.
to
we
your
might
point,
not.
if it's $500,000, what dollar figure are we willing to put into the program to make it happen? Is that 20%, $100,000, whatever? I just don't want the program to get a life of its own, and we say, why in the heck do we do this?
And I have no problem if we're thinking about a separate governmental agreement or whatever it's called with the city and my staff with respect to that, of going back and putting some thought into that, and giving you what we think it might take.
Dave's right. I think, we have times if Dave is willing to do it, to get a budget put together, okay, and see, okay, where are we going to be in relation to this? What's the cost to administer going to be? And if it's 10%, that's acceptable. If it's 20%, is 20% acceptable? I'm not prepared to say it is or isn't.
Yeah, I don't know where that number is.
I don't either, and I think also that we need to be very diligent in assuring that we don't build sunk costs into the Land Reutilization Corporation as part of this grant process. When the grant's over, the costs go away. They're 100% variable.
That's my point.
Yep.
And typically, just so you guys know, typically what we do with a state grant is, it's literally timesheet by timesheet, where Diane or myself or others who have been involved through the years will track our hours towards the grant. That's documentation, obviously, but it's also just, good record keeping as the grant. I can tell you, most consultants now probably are $150 an hour. We're not gonna be there. So you're probably getting a deal if we could, it's more allocation of staff capacity and time from my perspective right now. It's one of the things Diane's an expert in. She loves it. You have to find people that love this stuff. She loves it, and she loves seeing the projects done at the end of the day and done right, and she prides herself in clean audits and those sorts of things, so.
Yeah, I've really been impressed with her knowledge and detail, administrative detail, paying attention to detail. So, I think we're kind of stuck with the agreement. I don't think we really have any flexibility with a very, very tight timeline to negotiate with the Department of Development when they don't even respond timely anyway to routine questions. I think if we can get the agreement to go forward with this agreement, subject to any amendments, I mean, that's maybe encouraging, the Ohio Land Bank Association, which I agree is the right party to sit down with the DOD, because they're gonna represent 60 land banks or whatever there is. And if they come back with a revised agreement, then that probably should just improve our position. So then the big question is administration. And I know we talked way back in December or January when we first were working on this about hiring Montrose Group. We had a proposal from them, it was $5,000 a month to basically administer this program. Yeah, Montrose Group's a good firm. I have not talked to them. I don't know if they'd be interested in doing it again, but it sounds like Dave Eflin is interested in not volunteering, but for a fair reimbursement, maybe having Diane and staff take the lead. And that would give me great comfort, because I know she knows what she's doing, familiar with our situation, familiar with the county, familiar with the city, which is probably the two biggest projects of all of them.
And she's familiar with development, so she understands their
Yeah.
process.
Yeah.
It
So
makes
now,
sense.
I guess the question.
She's helped run grants that we, the city and county, have partnered on.
Yeah. Would you then outsource a supplemental, staff to Diane? Would you hire a temp or contract it out somehow to supplement Diane? So you think,
I think we keep it as simple as possible. We just do an intergovernmental agreement or whatever the form is that Scott tells us we have to use. Probably up to a maximum percentage of funds expended, or we could do dollars, or we could do I gotta think about that.
Sure.
Normal grant world, we're used to a percentage, 10 or 20% of the grant funds that we can rely upon for administration, because you may get down the road with a project and then a project falls off for any number of reasons we just discussed. But you have that time in it, working with them. And I can tell you, she wasn't tracking her hours because we're doing a pro bono to get to this point, but there were a lot of hours of working with some of our subrecipients. But all of them too. It's just a lot of work.
yeah,
But you're probably gonna come out ahead if we can figure something out than a private contract in terms of dollars spent at the end of the day.
and maybe efficiency too, because she knows what she's doing. She's familiar with the projects and the county and so on.
Yeah, just grant work's not all she does in my shop. That's the capacity thing. I gotta go back and really talk to her and figure it out for myself as a department. Obviously talk to Tom, city manager, who's our boss, so
Right.
figure that out. But I'm sure we have a project in this hopper, so I'm sure we're supportive of it. It's just a matter of figuring it out. It will take, I think, with Don and the treasurer and reimbursement, we're gonna have to
Cash.
keep working our partnership.
Cash movements, sure.
So I think what I'm hearing is we need to approve this today. Is that accurate? But we still have an opportunity down the road before these projects are approved by the state to determine whether administrative costs are reasonable or not. Is that a fairly accurate statement?
Yes.
Because I don't know what that number is. There is a number that it just doesn't make sense. That's the problem with government. We make it so expensive to spend $1 to get $1. It doesn't make a lot of sense. And I'm not suggesting that's the case here, but
I can't see us being over 10% of the total price.
so I would say
But,
that'd be
I
50
understand.
grand.
yeah, right.
Yeah, 10%'s
Uh,
10% is not unreasonable
Well,
at all. I mean,
if
you
it's
know,
10%, I'm all for it.
If,
I might even be okay with 15%, but
if somebody was ready to say, we'll do it for 10% today, and they were credible, I'd say sold. You know, so.
No, I agree.
I mean, I think there's three, assuming we approve this, there's three big tracks in my mind, and what I'm hearing is the admin, figuring that out. The insurance and liability, and making sure we understand what that means, and making any changes that we might need to make.
To the subrecipient agreement.
But as to the land bank, because this is between us
Oh,
and the
yes,
state.
yes,
At the
okay,
end
for
of the
this.
day, the state's gonna look at us.
Right.
We may look at a subrecipient, but they're gonna look at us. And then I think addendums to the subrecipient agreements as to beefing up the hold harmless clause, and we'll have some suggestions in that respect. And then also, I think, not advancing funds, subrecipients waiting until land bank representatives, and that could be Diane if we end up doing that contract, say, do A, and then do B, and then do C.
so when the state reimburses us, we pass it on to the recipient.
What normally happens is the recipient expends money.
Right.
Say it's Sunbury, and they need to do the asbestos study. So they get the go-ahead, they spend money on that, and then they request a reimbursement through us. We make sure the documentation is in line, and we request it, according to this, monthly through the state's electronic system. And then we get it and disperse it back to
So,
Sunbury.
yeah, when we get reimbursed, they get reimbursed. Just,
Yes,
Usually
I think that-
30
yeah, that's
to
right.
sometimes,
Yeah.
in old grants, it might be like 6 months later. Now I think the idea is to tighten up that time frame.
Yeah, I think we need to look for maybe some creative ways that are allowable to move that process, because in today's environment, I don't know that it's going to be realistic for the expectation that contractors are necessarily going to agree to wait 60 or 90 days to get paid. They're turning work down as it is.
Yeah. I think for things like items that produce paper, like an asbestos survey, that's one thing, but for the physical work, I totally agree with David. It's, first of all, we're gonna be under timing obligations as to procurement anyway, that are, I think, too tight in this environment, but they are what they are. And then just to, if you put it out there for bid or RFP, whatever local procurement is, or even estimates, I mean, I'm seeing contractors aren't, I'll hold it for 2 weeks, maybe.
You might not get any responses.
Or you
Or
may
you-
not get
or-
any, and the more
yeah.
restrictions you put on
That's
it,
right.
the less responses you're gonna get, but of course you don't know that till you get there.
so, but my concern is, we're asking the land bank to accept that liability versus the ultimate recipient accepting liability.
Liability,
If it doesn't, if for some reason the state decides not to reimburse
I think
something,
we've pushed
That-
all
that-
that
we push that to
down
the subrecipient.
in our subrecipient
Yeah.
agreement, but ultimately the state is contracting with the land bank.
okay, but okay.
They allow us to do subrecipient agreements, in my opinion, as Scott said. And we have agreements with them that pushes it down to them, but we would have to
We need to meet
enforce
our,
that.
we need to meet our responsibilities so we don't give them an action,
Yeah.
a cause for action that, I didn't get reimbursed because you didn't do this. You know,
That's what
we push it down on them and then make sure we're in compliance.
The reimbursement's the key, because that's my money. It'd be hard for them to argue, well, we expended these funds. If we didn't tell you, go, I don't think they'd have a leg to stand on the end of the day, because that's.
They wouldn't. But once we tell them to go, then we need to make sure that we're in a position to be able to fulfill our end of it.
Right. Mechanics. Details.
Yes, yeah, yeah. Okay, okay. Well, I guess I would propose that we get agreement today to go ahead, give as chair, and I would suggest we put in there vice chair in the absence of the chair, authorization to sign the agreement as it is, and if it's amended, then we'll have the ability to sign the amended agreement. That would be action item number one. Then number two would be authorized, go ahead and do an IGA with the city of Delaware to do the administration. But, so anyway, where's everybody on that? I mean, again, now maybe what we could do you know when the land bank, you're gonna hear from the Land Bank Association?
Well, I don't.
Okay.
All I know is that they are meeting with development. Supposedly they should be meeting with them while we're,
It's unlikely to come to a conclusion today. We can't get their meeting.
and, you know, we'll see where they get. I mean, the three things could happen. Nothing will happen, but they'll get some relief, or DOD will decide to make it more restrictive. So, you know, we need
And the
to,
next question is, when will they make a decision?
yeah, exactly.
Yeah.
You know,
So,
we need to have options moving forward, you know, so I think we, you know, if you're looking, Jeff, if you're looking for resolution, I think I would propose a resolution that we approve this grant document as it sits before us today, with the understanding that there may be revisions, and we want to reserve the right then to react to, and if necessary, either affirm or rescind this resolution. And it give the chair and the vice chair either the authority to execute on behalf of the corporation.
The motion,
I
think that-
hope it was.
I think it was a motion.
I second that.
Yeah.
I guess I would say, I mean, you have until, if the math is right, I
Yeah.
thought, Jeff, at the beginning of the meeting, you said until July 20th.
Yes.
And so part of Mr. Stage's resolution could be that you approve it and submit it no later than July 20th. I guess
Yes.
the second question would be is if this board hears back from the Land Bank Association that there are revisions, whether this board wants to call another special meeting or give the chair, the vice chair, the authority to sign the new revised agreement in lieu of this one. That's the harder question, I think, to Mr. Stage's point, rescinding it. Once it's submitted, I mean, you would have to put the Department of Development on notice, hey, we're terminating that, we're no longer, you know,
Right.
pursuing that agreement, or we're not in.
Yeah, I mean, it would be my intent to wait until probably the 19th to submit it, just because there's no,
Well, we have until close of business the 20th. I
Yeah,
think.
exactly.
It's submitted electronically, so it can be sitting there ready to go and send.
and hit send on the 20th.
I would just note, even in this program up to this point, if we aim for the 19th, that's a good idea, because everybody's gonna aim for the 20th, and the systems have
Crash.
had some issues. I just aim for the day before, just because of that problem.
Good point.
I think they probably give us another day, be my guess, but that's just, you're making an assumption at that.
Well, then I'll amend my resolution to
To submit by.
forward the submission on the 19th, by close of business
By
on
the
the 19th.
I'll second that.
Okay. You got that, Sarah? You think you got that?
Yeah. Do you want me to read it back?
Yeah, probably ought to.
Just a moment. Davey, or Steph, It's a problem with having two Daves on the board. So in the matter of approving the Ohio Department of Development Building Demolition and Site Revitalization Program Grant Agreement and authorizing the chair the chair or vice chair to sign the agreement by the end of day, July 19th, 2022. Sound good?
Submit, sign and submit.
Sign and submit.
Yeah.
Thank you.
Yeah, good point.
And
Okay,
that was motioned by David Stage, seconded by David Eflin.
okay. Any other comments, questions? Let's do roll call.
Mr. Eflin?
Yes.
Mr. Benton?
Yes?
Mr. Merrill?
Yes,
Mr. Stage?
Yes.
Okay, good. Okay, so we'll stay tuned. And Dave, if you hear before the rest of us, please circulate whatever
What about a
feedback you get.
motion to either authorize or request that Dave Eflin prepare a budget, grant administration budget for consideration, assuming we move forward?
Yeah, and then that's part of it, but then we'd have to do an intergovernmental agreement.
Yes.
Do an actual
Need
formal
something.
IGA. So authorize the budget and the IGA,
Yes.
preparation of budget and the IGA. Dave? Okay.
Not approving the IGA, you're just talking about for review at a later meeting?
Yes,
That's-
yes,
okay.
yeah, we'll have to have a special meeting, I assume, that we don't know, it probably doesn't make sense.
I don't know, we need a resolution for that.
I was gonna say, I don't think you need a motion for that, just ask.
For further consideration at
Yeah,
another meeting.
that's true.
We'll do it.
Okay. I really tell Diane, thanks, that's her expertise and your oversight, I mean, again, it's, you know, the treasurer's office did a great job in the earlier days, but it's a complicated process, but I think we're gonna end up improving 7 sites in the county. I didn't really have anything else. Anybody have any other?
Well, I would request consideration be given moving forward here that when a director is not able to make a meeting, we try to work with them to get alternatives.
Oh, sure.
You know, I don't know what all went on with, I don't even know what Mike's conflict was, Mike, Director Schuling's conflict was, because I didn't ask him.
Yeah. No, I agree. I was just hoping we'd get 3 people, you know, on such short notice, because this is so
Because I
timely.
do know that he wanted to participate in this, and I fully expect that he will be participating in any subsequent meetings we have about this.
Dave, I thought we changed the date so he could be here, is my understanding. I thought that was
This
what
was the
happened.
date that was proposed originally.
Yeah, this was the first chance. And once we got to 3, I was very
Well,
happy. because-
I asked for alternate dates, but nothing.
Okay, duly noted. And we, of course, we do want everybody to participate, but on a few days' notice, getting 4 people here was, I think, a good accomplishment. Anything else? Scott, anything else?
Nothing to add?
Sarah?
No.
Okay. All right, everybody, thank you again